Hello and welcome to our webinar on equitable enforcement and smoke-free multi-unit housing. As Stephanie mentioned, my name is Manire Vaughn and I'm an attorney here at the center. So before we begin, we think it's important just to tell a little bit about us. I'm sure we have a lot of people who've been here before, but the Public Health Law Center, we are a part of the Law and Policy Partnership to end the commercial tobacco epidemic. The partnership is a joint initiative of the American Lung Association and the Public Health Law Center to support tobacco control professionals in their work to end commercial tobacco epidemic in California. The partnership provides free technical assistance, research, training, and analysis to help communities pass strong local tobacco ordinances that are both effective and legally sound. So a little bit more about the Public Health Law Center. The Public Health Law Center is located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. We acknowledge that we are in the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in the area. The region is also shared territory with the Anishinaabe, also known as the Ojibwe or Chippewa, and the Ho-Chunk Nation also has historic relationship to the region. We appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which the law school sits. Relatedly, I also want to acknowledge the difference between traditional and commercial tobacco. Throughout this presentation, I will refer to the environmental impacts of tobacco, but I want to clarify that I am talking specifically about industrial scale commercial tobacco production. I am not talking about traditional tobacco as it is used religiously, medicinally, and ceremoniously in many different cultures. The Public Health Law Center offers free legal technical assistance to communities, public health advocates, and other partners. We also publish on important issues pertaining to commercial tobacco control, and we offer trainings and webinars. We do not directly represent folks, nor do we lobby. So the social determinants of health informs our work at the Public Health Law Center. This means that we acknowledge that there are several factors that influence public health, including racism, housing, environment, as well as a variety of other social determinants. In the context of the discussion today, we want to make sure that we are framing enforcement choices with the social determinants of health in mind. We never want to offer policy solutions that would cause someone to lose their job or housing and subsequently impact their health. So why equitable enforcement? All of our work here at the Public Health Law Center is grounded in health equity. This means working diligently to ensure that everyone has access to systems that promote healthy lifestyles. We are committed to removing all institutional barriers and applying an equity lens to our work to produce the best results for the communities that we serve. That said, enforcement should balance the goal of protecting the public from secondhand smoke exposure with knowledge that punitive measures are unlikely to help those struggling with tobacco addiction. Research tells us that the best approaches to helping those confront tobacco addiction, it's really a combination of things. It's counseling, education, and nicotine replacement therapies. Thus, enforcement should achieve the dual goals of protecting residents from secondhand smoke exposure while also ensuring housing stability for all residents whenever possible and really prioritizing treatment. So PHLC believes that housing is a human right that should be protected. As such, all policymakers and decision makers must explore enforcement options that eliminate or lessen the possibility of eviction. 28% of Californians live in multi-unit housing. 1 in 4 of those people are children. We know that in California, there is a housing gap, and there's a need to build at least 310 units per year for the next 8 years to close the gap. Existing housing in California is not affordable. On any given night, there are more than 100,000 Californians that are unhoused. Lastly, we also know that the California legislature has passed several laws to promote home building. So for example, AB 2011 let home builders bypass the local approval process and build housing on some commercial land if a certain percentage of homes they build are affordable. Also, SB 86 lets developers build market rate housing on commercial land but remain subject to the local approval process. And both of these were signed into law in September. So disparities in secondhand smoke exposure, multi-unit housing, right? So The focus of today's conversation truly is equity. So we thought it was important to just really set the stage for what's happening now. So according to the CDC, it's estimated that approximately 80 million people live in multi-unit housing. Approximately 7 million of these individuals live in government or subsidized housing. It is also estimated that we spend approximately 69% of our time in our homes, which is probably a much higher percentage since the pandemic. Lastly, we know that marginalized groups and those who have a low socioeconomic status, Black, Indigenous people of color, people with disabilities, and the elderly tend to be overrepresented in multi-unit housing settings. So from these statistics, if we just look at the smoking rate in multi-unit housing, the amount of time people spend in their homes and the overrepresentation of marginalized groups of people, we know that these groups often bear the health equity issue that needs to be addressed. So let's talk a little bit more about housing first. It's something that we've been talking about a lot, specifically in California. And, we thought it was important for us to share that many jurisdictions across California have explored housing first, smoke-free multi-unit housing policies. For those of you who are unfamiliar with the term housing first is an approach that is based on a hierarchy of needs. So it acknowledges that people must have basic life necessities, such as a safe place to live and food to eat, before they're able to pursue quality of life and personal goals. Housing first models are typically an approach to serving unhoused persons. A housing first approach would not support eviction or criminalization for smoking in multi-unit housing and does not require tenants to engage in programming to maintain their housing. And with that, I'll turn it over to my colleague, Jamie.
So as Manire mentioned, we know that there are disproportionately individuals living in multi-unit housing who are people of color, low income, and children. And so there's many reasons why we are concerned about the exposure that these individuals are receiving from secondhand smoke. We know that secondhand smoke is a toxic contaminant. We know there is no risk-free level of exposure. The California Air Resources Board has included secondhand smoke in the same category as the most toxic automotive and industrial air pollutants. And the American Society of Heating, Refrigerating, and Air Conditioning Engineers has said that there is no acceptable indoor air quality in multi-unit housing without the absence of secondhand smoke, cannabis smoke, and aerosol from electronic smoking devices. We also know that secondhand smoke transfers between units, and research on children who live in homes in which no one smokes indoors, comparing multi-unit housing residents versus detached housing, have found 45% higher cotinine levels in children living in apartments compared with detached homes. So we know that kids are getting nicotine exposure just from living in multi-unit housing. We also know that in multi-unit housing, third-hand smoke is a real concern. So this is the residual nicotine and other chemicals that are often left on furniture, walls, or other surfaces by commercial tobacco smoke. And this is also toxic, particularly to children who may be crawling along a rug or interacting with it at a much closer level. So in Los Angeles County in 2020, for an example, 39% of multi-unit housing residents said they were exposed to secondhand smoke from cigarettes, 9% from e-cigarettes. So we know that this is a significant challenge for multi-unit housing residents. And that's why we've seen so many jurisdictions in California step up to act. 76 so far, cities and counties have adopted smoke-free multi-unit housing policies. And these often include both multi-unit housing apartment buildings, as well as condos and homeowners association run organizations. Many of them do also include electronic cigarettes, as well as more traditional tobacco smoke from cigarettes. And then cannabis has also recently been a hot topic that a number of jurisdictions have included in their multi-unit housing ordinances. And we can get into that discussion more in the question and answer period as well. So when we're thinking about equitable enforcement and what that means in the context of multi-unit housing, one question is, who is going to do the enforcement? What will result in the fewest potential negative collateral consequences? And also these questions often might be jurisdiction specific based on their resources or the size of that jurisdiction. So a public health department might be involved in enforcement in some jurisdictions. Landlords could be brought in to provide enforcement. City or county attorneys sometimes can step in and take action at the court level. Tenants themselves can be given the opportunity to enforce. And then police also in some jurisdictions are involved in enforcement. So before getting to the stage of enforcement, though, it's important to start with education. Engaging in an education campaign, such as providing educational materials or presentations for residents, staff training, and signage or notices to residents can greatly reduce the number of tenants in violation of any policy. Most residents are not going to smoke if they see signage or if they know that it's against the building policy. We also know that there will be greater compliance overall if the policies are easy to understand and are well communicated, if the areas where smoking is not allowed are clearly identified, if the public and landlords are informed, and if the policy applies to everyone equally. Ordinances that are drafted by local governments can be very specific about the signage. Our model policy requires, for example, that there be sufficient numbers and locations to make it obvious to a reasonable person that smoking is prohibited in all units. We also require that the signs be posted in common areas, at entrances and exits, and at conspicuous places around property grounds. So you can get very specific about how you want the signage to appear in particular properties. We also want to make sure that there's sufficient lead time when you're implementing a new policy before it's adopted to engage in education. So our model policy recommends 3 months' time to be able to get the word out to landlords and residents. And to Manire's point about cessation being the most effective treatment for those suffering from nicotine addiction, we wanted to give this example from the Alameda County Public Health Department. This was a postcard that they sent out to residents ahead of their smoke-free policy taking effect this past summer, and has a lot of great information for individuals about the policy that's going into effect. But as you can also see in the bottom right, there's information on how to quit smoking, including a link to cessation efforts. So I think this is a good example of being able to promote behavioral change and support people in quitting, even as you are getting information out about a new policy. So we're going to talk today about a publication that we put out just last month, which is Smoke-Free Multi-Unit Housing Enforcement Guide. And for those of you who are tuned into one of our previous webinars, we also put out guides for tobacco retail licenses and for outdoor area smoke-free ordinances. And we did webinars on both of those and those enforcement guides. We've used a consistent rubric throughout to have green be the most preferred and most equitable enforcement options. Yellow would be proceed with some caution, and red would be not recommended. And these guides are intended for California communities that are ready to address equitable enforcement of smoke-free multi-unit housing. We worked in close partnership with the California Tobacco Control Program to prepare these, and went through an extensive comment and revision process with many statewide and local stakeholders. So the overarching comment for the guide is that you do want to have multiple enforcement mechanisms in an ordinance to increase the likelihood of compliance and protect from secondhand smoke. So with that, I will jump into some of the enforcement options. So our first green option is graduated enforcement by a landlord. So graduated enforcement means having increasing consequences as a violation is repeated. So you can have tiered steps, such as providing cessation materials or verbal or written warnings to start, perhaps leading to informal consequences or written acknowledgement that a policy has been violated. We know that providing cessation materials can help, as was mentioned, the smokers directly who are affected by smoke-free policies to quit. The graduated enforcement could also have resetting the clock options. So for example, if a year has passed since a first violation, then the clock can reset so that you're not going up the ladder of consequences in perpetuity, but you are given a chance to do the right thing and to try to not smoke against the policy. There also can be prohibitions on evictions written into the approach for graduated enforcement, which can help make clear to the landlords that we're trying to have the enforcement be about getting the individual's help and stopping the harm, but not about eviction. We also know that one caution, though, is that we know that sometimes steps like this may not be enough to obtain compliance, so there may need to be some stronger penalty options as well. A second possibility for enforcement is having civil fines against landlords or HOAs. So if you are putting landlords and HOAs on the spot for doing some of the initial enforcement, then it makes sense to also make sure that the landlords and HOAs are held accountable for making sure they are keeping their properties smoke-free. So that can include civil fines if landlords are violating smoke-free ordinances, and this can be an effective incentive, of course, for having the landlords be enforcers. These can also be graduated, so they can start at a lower level and move up over time. We also know that enforcing against landlords can limit some of the potential negative consequences of direct enforcement against tenants, such as civil fines or other penalties, which can trigger some of those challenges that Manire talked about with the social determinants of health of individuals potentially not being able to afford some of the penalties, or that leading to other collateral consequences for those individuals. You can allow tenants to initiate enforcement against landlords by registering a complaint with a designated local government employee as a way to trigger enforcement here. And one caution, though, is depending on how the ordinance is structured, if you put landlords on the hook for enforcement and or fines as a penalty, but eviction is left open as an alternative, then that could incentivize landlords to want to evict tenants that are continuing to violate the policy. A third option would be to pursue a restorative justice approach. So restorative justice focuses on repairing harm caused by a violation and reducing future harm, and it involves a cooperative process where stakeholders must be willingly brought together to discuss the harm and see how to bring a resolution. So, for example, if a complaining tenant and their neighbor both agreed to a restorative justice process, this could be a way to bring them together to provide an alternative to a fine or another type of enforcement. And it can be an effective way to help the individual who was committing the harm better understand what their impact was on their neighbor. And that can potentially be transformative in terms of seeing behavior change. One of the challenges here, though, is that it does require the involvement of an individual who is trained in how to oversee restorative justice practice. So that can take some budget impact, and it does require willing participation. It does not work if everybody isn't willingly there, and so it's not always possible to use this approach. Another option as an alternative to a civil fine for residents might be a community service option. So this could also be tailored to a tobacco purpose, such as a tobacco waste cleanup effort. And that can limit the financial hardship on residents compared to some civil fines. But a caution is that it can still pose some hardship to individuals if they are required to miss work or arrange for childcare. And depending on how it's enforced, could open up the door to some other collateral consequences as well. And it also may require some new programs to invest in if these don't exist in the community as they are. Another green enforcement option is nuisance. So a public nuisance is a legal doctrine that applies when a person unreasonably interferes with a right that the general public shares in common. So these tend to be enforcement approaches that jurisdictions have written into their local code. and local ordinances can simply declare violations of a smoke-free ordinance to be a public nuisance, which would open up a range of enforcement options. And those could include restraining orders or preliminary or permanent injunctions against individuals who are violating the policy. Some cautions, though, is that it does require some local resources to be able to be widely used. And there could be some involvement for law enforcement in having these policies enforced. And there also is the possibility, depending on how the nuisance charge is brought, of having escalated consequences or misdemeanor charges in some jurisdictions. And a final green option is enforcement through the lease. And so in many policies in California, there are smoke-free requirements in the lease terms. And this can create some clearer expectations for new and existing tenants about what the options are, what the requirements are of living in the multi-unit housing setting. One caution, though, is that depending on how this is drafted, it could allow for evictions, which we know can impact health outcomes. And we'll get into a discussion of that a little bit more detail in a minute. So next, we'll talk about some of the caution or yellow options for enforcement. One would be civil fines against tenants. So this could be enforcement by housing inspectors, health departments, or other civil employees. And it does remove potential collateral consequences from a police or a criminal style enforcement. And it could act as a deterrent for individuals to smoke in some circumstances. A couple cautions. One is that there could be a budget impact if you're adding new duties to city or county workers. But the primary caution is that administrative fines may cause financial hardship depending on a resident's financial circumstances. And that financial hardship could lead to other collateral consequences that impact that individual's health or have negative harms that are not necessarily related to the health goals that the jurisdiction has. There's also a risk of discriminatory or unequal enforcement against individuals depending on how this is enforced. So our model ordinance does not include civil fines against tenants for these reasons. And instead, we focus at the Public Health Law Center on enforcing against landlords and HOAs. Civil right of action is another option that we put in the yellow category. And so this would allow private civil actions from a tenant to help ensure there is adequate enforcement of the smoke-free policies. It can give some agency to tenants to act on their own behalf. But it depends, in our view, on how it's structured. If there is an option for a private right of action against another tenant, then that can lead to a risk of discriminatory or unequal enforcement, depending on which tenants are bringing them and for what reasons. And that can also create some distrust sometimes or hostility between different tenants. It also can create some burdens on the judicial system and can sometimes be difficult for litigants who are bringing these cases themselves to prove that smoking occurred. So often a civil right of action may be better brought against a landlord or against the jurisdiction itself to make sure that the penalties are that the ordinance itself is being enforced. So that brings us to eviction, which we've talked about. Manire, I think, set this up well in terms of the potential harms of eviction and the housing crisis that we know Californians are facing. So in limited circumstances, eviction could be used as a last resort for repeat violations of no smoking policies to protect the health of other tenants. And these are decisions that each individual jurisdiction is going to have to weigh about whether they would view it as a larger harm to equity to evict somebody or to allow that individual to stay in the unit if they are not ceasing their smoking activities and are causing health harms to other residents. There is the possibility for graduated enforcement to perhaps specify a certain number of warnings or violations before an eviction could proceed. So this would at least allow for multiple chances to comply. And another alternative would be to allow for a non-renewal of a lease instead of an immediate eviction. So that would at least give individuals more time to look for other housing than if, for example, there was a short turnaround eviction proceeding. So cautions about thinking of eviction in limited circumstances. One are the worsening the existing economic disparities and health outcomes, which Manire did a good job of setting up in his section. It also can make it more difficult for individuals to obtain other housing if they have an eviction on their record, and that can set off a potentially negative spiral. It could sometimes be used as a pretext to remove a tenant when a landlord or another resident wants to have somebody out of that housing for a reason that's unrelated to their smoking. And if the eviction could be applied to a resident for actions of their guests, then sometimes you can penalize the tenants for others' actions. And so they might not be violating the policy themselves, but somebody staying in their house or their apartment could be, and that could put them at risk of housing insecurity. Also, knowing that eviction could be an outcome for a neighbor in a circumstance where there is this housing crisis might discourage other residents from reporting smoking policy violations. And there's a risk that, as was mentioned with smoking by guests, if it's an elderly resident and there's another family member smoking, that could put an elderly resident at risk of housing instability. So we do not recommend, as a result, eviction as a first response. So using a one-strike approach or allowing an eviction just for a single violation is something that we suggest not using as an inequitable approach. And we certainly suggest for first violations, giving tenants an opportunity to correct the violation, and also having the opportunity to pursue cessation options. So eviction, of course, is a big conversation that is happening even outside of the smoke-free multi-unit housing context in a lot of jurisdictions. And so these conversations will often take place in the individual context of a particular jurisdiction, but Public Health Law Center is happy to help walk through some of the options that folks have and approaches that different jurisdictions have taken, from a housing first model, as Manire has mentioned, to ways to minimize harm if a jurisdiction still does want to keep eviction as an option. And then finally, the last alternative for enforcement I'll mention is another that we recommend against, which is criminal enforcement. We don't see positives to having a criminal enforcement in a smoke-free multi-unit housing context. Criminal sanctions have been shown to have negative public health consequences and lead to inequities. There's histories of racial profiling and discrimination in the enforcement of many crimes, including lower level offenses. But one of the main concerns is that criminal process can lead to collateral consequences. And so those could include impacts on immigration status, triggering probation or parole violations, leading to summons, which could then lead to criminal records or a warrant, and potentially increased distrust of law enforcement. So I included as well this slide from the Federal Government Accountability Office. This is looking at nonviolent drug convictions, but a lot of these could also apply to other similar low-level criminal convictions, such as convictions for smoking. And when asked to categorize and tally up the number of federal collateral consequences just for nonviolent drug convictions, the Government Accountability Office found 641. So that doesn't include state and local collateral consequences, and we know that there are many. So last thing I'll want to give an example of is mentioned the postcard that Alameda County sent out, and thought it would be useful just to highlight one example of how one jurisdiction in California has thought through some of these enforcement discussions and the outcome that they landed on. So Alameda County, in their policy they adopted this summer, puts the public health department front and center in working through enforcement, and they are responsible for issuing warnings, which include educational materials on cessation. And 3 warnings are required from the public health department before enforcement action is taken. Once enforcement action begins, there are graduated penalties for tenants. Those include the 3 you see here, $100 for the first, up to $500 for third or more. There's also the option to bring civil actions for the county attorneys. And then there is a requirement that there not be eviction unless there have been 3 written notices to the individuals. So wanted to at least provide one example of how some jurisdictions are thinking about the balance of making sure that there's equitable enforcement. And here's our contact information. With that, I'm going to turn it over to Jenna Grosser, who's the Senior Program Consultant with the California Tobacco Control Program. Have her make any comments she has on things that Manire I might have left out, and then we will turn to questions. So please put your questions in the Q&A so we can get to them. Jenna.
Hi, thank you guys for having me again for this third in the series. Multi-unit housing is definitely a complex area, and it's definitely something that California's kind of always taken the lead on. So what we're able to do here is really set standards and find best practices for the rest of the country as multi-unit housing becomes a more popular policy to work on. So I'm really grateful. There are a lot of good questions already in the chat. So I think I'll stop there and say, let's get to those questions and be able to add on to that.
Absolutely. Thanks again, Jenna, for joining us. And so we have a few questions in the question answer, and then there are a few other questions. So the first question is, how does a landlord prove that a tenant is smoking? I have some ideas, but I'm curious, Jamie and Jenna, if you have any thoughts.
Sure. Well, it's important to document any complaints that are coming in. So oftentimes it will be a tenant who is complaining to the landlord. And so you would want to recommend that the tenant write down the time and location of when they experienced secondhand smoke. And if they have a particular reason to believe it was a certain neighbor, they can write down any details that they have to show that was why they think it was that neighbor. So for example, I saw my neighbor smoking on their patio, right? Or something along those lines. Typically you can tell, where the smoke is coming from, but if you can't, you want to just write down any information you have, and then it will be up to the landlord to try to determine if they can identify the source of secondhand smoke. I don't know, Manire, if you wanted to add anything to that.
Yeah, so before joining the Public Health Law Center, I was a housing attorney here in Minnesota, and I dealt with smoking cases. And, I've seen quite a few landlords be creative when thinking about proving smoking cases. As Jamie mentioned, I think it's really important to document. But in addition to documenting, I think also, having conversations with residents and asking, are you smoking? If they answer and say, no, they're not smoking, showing them the evidence that you have and saying, during this time, this is when, your neighbors have complained of smoking. And I think a lot of times when you're honest with residents and saying, we know what's going on, they tend to be a bit more like, oh, snap, I got caught, right? And wanting to solution build and think with the landlord. So I do think it's important to make residents aware of the documentation, but then also knowing that this is something that's going on and it's not just like a one-off thing.
Yeah, I agree with that. I was just going to say, I think most people want to do the right thing. So if confronted with the concept of, hey, you're not supposed to be smoking on the, on the inside, or it is bothering your neighbors, most people want to do the right thing. It's for those cases, and I know our projects are regularly confronted with those cases where Maybe people are acting a little more egregiously, but that's not the norm. It's not. So most of these policies can be enforced by making sure people are aware that they exist, that they're there to protect, and making accommodations if and when they're needed.
Thanks, Jenna and Jamie. Okay, our next question. Within their multi-unit housing ordinances, have any larger California cities incorporated civil fines against landlords or HOAs instead of fines against tenants?
That's a good question. I know that there are jurisdictions outside of California that have done so. I don't have every jurisdiction memorized in California in terms of their enforcement protocol. So I don't have one that is coming to mind. I don't know, Jenna, if you have one that off the top of your head.
Yeah, I saw this question earlier and I was like, oof. It's not something that we naturally track in like our pets database. A specific city where the landlord themselves is subject to a civil fine, I don't have any recollection. So if you know of something, or one of your cities does do that, please put it in the chat.
And I think another thing that I've seen is some municipalities have made the landlord act before they will weigh in on a situation. So I have seen where it says like the landlord has to, do something. So they have to either, try to speak with the tenant or, apply various measures before the city will actually intervene on a situation. So I have seen that. I don't know if that's a larger city, but I think that is an example that we've seen in California. Another question we have is, it's related to nuisance. So specifically, the person they said, I am surprised that nuisance is a recommendation as an equitable option because of the danger of discrimination in police enforcement. Any comments?
Yeah, absolutely. So it's a good question and good comment. So nuisance is, I would say, an active topic of conversation with us and a lot of our partners. It is pretty commonly used by a lot of California jurisdictions at the moment in most of their ordinances. We tried to give the benefits and cautions so that, it was highlighting the positives that could be seen from nuisance as well as the negatives. And so the positives include that there are options like restraining orders or permanent or preliminary injunctions, which are good tools to have. And those are ones that aren't going to result in the same kinds of collateral consequences as the ones you're talking about, and can be a strong consequence for somebody who's seen repeat violations. But we do highlight that there are the possibilities of escalated consequences or misdemeanor charges, and those are certainly cautions. So we know some jurisdictions who've decided not to include nuisance in their ordinances because of this, and it's certainly something that when jurisdictions are particularly concerned about criminal enforcement or collateral consequences, we would probably recommend against including nuisance as an option.
Before we go to the next question, Jen, any thoughts?
I mean, I agree. I think out of all the workable solutions, nuisance is probably the one that I hesitate against them, with the most, because of the reasons people bring up, because it does tend to have law enforcement there, but it is an option. And so I think having a slate of options is really important, because what you want to do is build your ordinance with your community. And until you're talking with your community and what your community finds to be acceptable, and I want to get more specific on that, not necessarily the community at large, the people who will be impacted by the policy, for better or worse, right? Multi-unit housing residents, people who own multi-unit housing, people who may, I think there was a note in one of these questions about people who live near multi-unit housing, but maybe it's California, we have crowded neighborhoods, you have single family multi-unit next door to each other, right? Engaging more people is going to get you the solution that works best for your community. It's going to get you to work with the enforcement agency that the community is most comfortable with. And so that, as much as everybody, I think, tends to want to give me the best practices from city A or B, the best practices from city A or B may not be the best practices for your community. And so here is a slate of options for you to consider. Nuisance might be the best option in some communities, and other communities, it just doesn't work. So it's pulling those people together who know their community best, know what they're comfortable with, and then advocating for the strongest thing that's going to protect the most people, because that's our mission in public health.
Thank you. So one question is about designated smoking areas. And one person asks, within the multi-unit housing model ordinance, is there language to recommend a smoking area on the property, keeping that all tenants in mind? There will be people with physical challenge that make it very difficult to leave their apartments and to go somewhere else to smoke. How do landlords be recommended to engage with these tenants?
So we do, this gets a little beyond enforcement, but in terms of how the policies are constructed, we typically advise not to include designated smoking areas if possible, and to have policies that prohibit smoking in all on all parts of the property, common areas, and including a buffer area around doors and windows and the like. But we do include in our draft ordinance an option for designated smoking areas for those jurisdictions that want to pursue that. So, for example, if a jurisdiction has embraced an entire smoke-free outdoor air policy that includes, no smoking on sidewalks, and they want to implement a smoke-free multi-unit housing policy, then they may be looking at a designated smoking area as a way to have at least one option for a location for people to smoke. So we do include language that provide some guidelines for how to do that in as protective of public health means as possible.
Jenna, any thoughts?
I think that was good.
Okay, all right. So one question is about landlords, and that is many landlords express fear that a judge will rule against them in an eviction case for various reasons. How often does this happen? And then I think the second part of that question, or what they're getting at, is how do we get landlord buy-in when it comes to smoke-free multi-unit housing policies?
I would say first and foremost, design the policy with landlords. Keep in mind that when we're talking about multi-unit housing, it's an incredibly diverse slate of what we're talking about. 2 or more units that are attached in some way: floors, walls, ceilings, ventilation shared, etc. So you're going to have a wide variety of landlords, owners, with different wants and needs, but engage them first. And then I think the question disappeared. I think to the question Debbie was asking, I don't know how often a landlord's really going to come down on, I don't know if there are statistics around how often a landlord is ruled against by a judge, but I think a lot of that fear can be sewn up by having these policies in place, by having these policies that dictate what the flow is. That's very clear, the graduated enforcement. If a landlord is fearful that they're going to get in trouble for evicting somebody, it's probably because they did something wrong. If your graduated enforcement is really clear and they followed it to the T, then that's the law, and a judge is going to confirm that. So that's my initial take. I don't know if a lawyer has a better take on that.
I mean, I'll just jump in and say that, smoking cases can be incredibly difficult, in part because of the proof piece and, providing evidence to the court. As Jamie spoke about lease addendums and things like that, in the event that a person violates their lease, and that's a basis to evict someone, as Jenna mentioned, now we're just dealing with straight up, what does the law say? And I think that, if the person says, well, I wasn't smoking, again, going back to the evidence that the landlord is providing the court is really key. And that's really how the case will shake out, depending on the evidence that's provided, the defenses that are raised, and, just making sure that we're covering all bases if the case does go to the courts. So someone also asks if there are any jurisdictions with smoke-free multi-unit housing that have smoke-free multi-unit housing policies that have seen a reduction in tobacco usage as a result of the policy, or at least any reductions in youth asthma related ER visits?
That's a great question. I don't know if I know a study that specifically answers one of those two factors. We certainly know that there are reductions in multi-unit housing from the policies themselves, but I haven't seen it. I'm not thinking at the top of my head of a jurisdiction-wide study. I don't know if Jenna, if you know of one.
Yeah, most emergency rooms don't ask about housing type in intake. So that's really hard data to come up with per se, to say like, because of multi-unit housing policy, we saw fewer ER visits from youth who live in multi-unit housing. But historically, anytime a smoke-free policy is put in place and put well in place, it's not just asthma, it's not just youth asthma. You see reduced ER visits, period, due to asthma. You see reduced cardiac episodes in ERs. You see that community-wide impact that a really good policy can be put in place. So if we're talking about a rural community where you're fighting for, 100 housing units, maybe countywide, you probably aren't going to see significant data. But if you live in one of those major metropolitan cities where basically everybody lives in MUH, you're going to see a bigger impact. And I think that you would be able to really look at and call to. But if you want more data and or you want to work with like TRDRP partners to like encourage them to study this, I think asking the question at intake would be the best way to ensure that you're getting the right data.
So a few of the comments in the chat, is really about what people are seeing on the ground, so specifically seeing folks call when issues are escalated, and having to deal with tenants who, and many times feel like they're being forced to move or evicted because they're being exposed to secondhand smoke. So I guess one of the final question to you both is, what are some tips that you can give tenants who are, experiencing secondhand smoke exposure? So we get TA requests all the time from tenants, but if we could just give folks a few pointers in terms of how to handle situations when they either have a call from someone that's experiencing secondhand smoke, or they themselves are experiencing secondhand smoke, from their neighbors.
That's a great question. So we did put together a tenant guide in both English and Spanish. Hopefully, Stephanie, if you wouldn't mind seeing if we could throw that in the chat for folks. So that is a tool, a resource that you can share with tenants who are experiencing secondhand smoke, and walks through their options for steps that they can take, both legal options and recommendations about how to work with their landlords or with local jurisdictions. So hopefully that's a top to bottom guide for most tenants. And I also heard the question as well about struggling with the balance of equities of people who might be facing losing their home because they can't stay anymore with the burden of secondhand smoke, and that certainly can be a reality too. So these aren't easy questions, and we know that there are balancing equities in terms of protecting public health and keeping smoke-free residences. So certainly when it comes to penalties, there are other penalties that we think can lead to individuals complying with a policy other than eviction. But as we put in our in this policy, we have left open the option for those jurisdictions that want to pursue eviction in those real outlier circumstances where you have 3, 4, or 5 warnings, attempts at enforcement. So those are calls that I think individual jurisdictions are going to want to make. But for a jurisdiction that doesn't want to see eviction, there are other options. You can have, graduated enforcement penalties that have some real consequences, or you could have, for example, the options we talked about earlier with some of the nuisance actions, restraining orders or the like, that could be pretty serious consequences for individuals if they're not complying fully. Jen, I don't know if you wanted to add anything there.
I feel like I have so much more I want to say on this whole topic with only 7 minutes to go. I think I think the first thing I want to say is, and I think Andrea made this point earlier in the chat from Orange County, is that if we're not talking about evicting people who smoke, we're talking about evicting people who don't smoke. So often the calls that you're getting are people who are going to have to pick up and leave their home because a policy is not in place. And I think it's good. And I've spent a lot of my time at CTCP dealing with a lot of these individual calls to the state, calls for help, individual tenants who need that help. But the best thing we can do for them is get that policy in place as fast as possible so that there's something to enforce, because otherwise those people are going to have to pick up and essentially be voluntarily evicted from their own homes. They're going to have to move someplace else. They're going to have to go someplace else. So if eviction is a concern, remember that it goes both ways. It goes both ways. And having that policy in place means following a rule. If there's no rule in place, people who are trying to keep their kids healthy, who need to breathe clean air, who might have asthma or other health issues that put them at risk, are being evicted at a time when they don't have the ability to lose housing in a market where it's so hard to find housing. So it goes both ways. Equity goes both ways. And having this equitable conversation, the policy needs to exist as strong as possible to protect everybody across the board. Like, that's just everybody. If you live in multi-unit housing, you have a right to a healthy, clean home. And we guarantee that on a number of other things, from asbestos to lead to other healthy housing standards. We've guaranteed this. Tobacco environmental smoke is part of that. Cannabis environmental smoke is part of that. So everybody has that right. And I think while it's important that we're taking those calls and we're helping the folks who are asking us for help at the time when they're asking for it, if we are not as quickly as possible converting those people to the advocates, we're not setting up meetings and putting them in their city council person's office and saying, this is what's impacting me right now. I need help to do this. You will spend all of your time working with one or two residents and the landlords and trying to negotiate something that won't get you anywhere near what you need to or protect people in the long term, is working on that policy. So what I want to carefully say is, like, don't take your eye off the ball. The ball is policy. It's getting the policy changed so that everybody gets it, so that it's enforced equitably across the board. That's how we do our best work, our most work, and do so effectively too. So I think that resident engagement, if you're getting calls from folks, how quickly are you getting them to a meeting? How quickly are you connecting them to the city council? How quickly are you raising this issue that policy must be passed? That is my advice.
Thanks, Jenna and Jamie. I think we've answered all of the questions. So with that, if we do not have any additional questions, I'd like to thank everyone for joining us in our webinar today. Of course, if you have any follow-ups, please feel free. I believe Jamie, in his last slide, dropped our contact information. So please feel free to reach out to the Public Health Law Center. We're more than happy to talk through a lot of these things with you, specifically in thinking about how to tailor a model policy to your jurisdiction. So that's the cool thing about our policies, is that they are incredibly tailorable, and we welcome opportunities to work with communities in figuring out what's the best policy solution for them. So if Jamie and Jenna do not have anything else, with that, we'll end our webinar. Thank you.
Thanks, everyone.
Thanks.